Good morning. My name is Ann Gannon, and I'm the Palm Beach County Tax Collector. I'd like to welcome you to the Honest Services and Public Integrity Workshop. I'm sure all of you are asking why the tax collector is interested in this topic. Well, our office collects about $3.2 billion in revenue each year, and we handle millions of dollars in contracts yearly. Sometimes our employees are asked by our clients to bend just a little to benefit them. When I was elected, one of the first items on my agenda was to visit all of our branch offices. I encountered an organization furnishing lunch to our employees because they wanted us to market and sell more of their specialty license tags. Why? Because they get a portion of the money to run their organizations. I don't believe public sector employees or public facilities should be used to market a license plate for a private organization. Ethical behavior is not just about elected officials. It applies to everyone in our office, not just me. After witnessing those luncheons, I implemented an agency-wide no-gift policy. It goes beyond the rule of law and prohibits any employee from taking a gift of any value from a client or a vendor. If we do receive a gift, we pass it on to charity. The Lord's Place has truly benefited from our no-gift policy. Our agency takes the value of integrity very seriously because our agency staff interacts with the public each and every day, and the professional behavior we exhibit is a key part of that interaction. After implementing our ethics policy last month, we also instituted a third-party ethics reporting system. We are the first government agency in Palm Beach County to implement this program. The program offers an employee an interview process via a website or phone to report ethical breaches, which are then investigated. So I will tell you, the inspiration for this workshop came to me last month after talking to a number of colleagues and peers about the lack of ethical climate in Palm Beach County. I decided we needed to take the conversation about ethics and public corruption to the next level and invite the legal experts, public officials, and community stakeholders to begin that conversation. Seriously, I'd like to thank all of you for showing up today. We're honored to have a distinguished panel of legal experts and an attorney who represents clients before public bodies. We have over 90 attendees from municipalities, public boards, public staff, and community leaders. They are from throughout our county: Wellington, Delray Beach, Lake Worth Drainage District, our county commissioners, and we'd like to thank them for stepping up to the plate to begin this discussion. The truth is that those of us involved in the business of government approach most decisions with noble motives. Unfortunately, the decisions made by a few local public officials and business people have tainted the reputation of our county as a whole. The goal of today's workshop is to give you a better understanding of the laws surrounding honest services fraud and public integrity and how this law relates to ethics laws in Florida statutes. We hope that you will leave with a renewed sense of where the lines lie in terms of integrity and ethical behavior for elected officials, advocates, and the business community. As we say in our agency, if in doubt, don't do it. I wanted to personally thank Jamie Titcomb. He's the Executive Director of the Palm Beach County League of Cities and the League who partnered with us to organize this workshop. Jamie is the Chief Administrator responsible for facilitating advocacy, lobbying, and educational efforts, communication, managing membership events, and external public relations. And for those of you who don't know it, he's also a former elected official serving on Boynton Beach City's Commission. Jamie is going to introduce our distinguished panel of legal experts. Then we'll start the workshop by hearing from each of our panelists and their perspective of today's topic. And as you entered the chamber, everyone was given an index card for you to submit questions. After hearing from each of our presenters, Jamie and I will facilitate the questions that you submitted. A couple of housekeeping items. Our volunteers today are directors from the tax collector's office. They're all wearing black suits and will be walking around the room to collect your cards. After comments from our speakers, there will be a question and answer period, which will run approximately 30 or 45 minutes. We are very fortunate today to have both state and federal prosecutors participating in today's panel. Under their respective rules of ethics and practice, however, they cannot give legal advice about whether some future contact or conduct would be criminal. So please, in crafting your questions for the panel, please try to avoid hypothetical questions seeking legal advice. Instead, you probably should hire Bruce, who is a former U.S. attorney, and maybe he needs to build his legal practice up, and pay him to answer your questions. Now let's introduce the panel, Jamie.
Good morning, everybody. Let me just take one moment to echo some of Ann's comments. Why would the League of Cities be here and partnering in this endeavor today? Well, as you probably know, we represent 38 municipalities, which translates to 230 local elected and appointed officials. And I just wanted to tell you that in Palm Beach County, because of the highly publicized cases, our brand has been tarnished a bit. And it's sad because it's a very small number of people, a small handful that has brought a lot of negative attention. And I work for so many wonderful people that, like myself, when they got into public service, they did so for the right reasons, and each and every day they work for the right reasons for the community. And I'd like to underscore that we thank you for all your public service to the community. We learned when we were early in grade school, perhaps, that lying, cheating, and stealing as a method to win your way or prevail is just not acceptable, and we gravitate away from those people. Everybody sitting here, we're preaching to the choir, but this is such an important endeavor that we're doing here today. I want to thank the tax collector. I want to thank the tax collector's staff. I want to thank the county, TV20, and all the League of Cities members that have participated in this effort. I also want to thank Leadership Palm Beach County that has put forward an ethics pledge and a culture of ethics as an initiative towards this entire endeavor. And with that, I just want to say that the League of Cities stands 100% behind good ethics and good governance and best practices in Palm Beach County, and we will continue to be here always to make sure and help that happens. With that, it's my job this morning to introduce our esteemed and distinguished panelists, and I have some very brief bios. I will ask the panelists also to fill in some important information that I won't tell you about them. But just to give you an idea of who we have here today, first representing the Assistant U.S. Attorney's Office, Rolando Garcia. This office enhances the public integrity by investigating and prosecuting federal, state, and local officials for violations of federal statutes covering bribery, graft, conflict of interest, embezzlement, and extortion. Mr. Garcia is here representing Mr. Kastronakis, who could not be with us today, and we look forward to his comments. Next to Mr. Garcia, we have Mr. Bruce Reinhardt. Bruce, as you heard, is a former federal prosecutor who is now a criminal defense lawyer in West Palm Beach, specializing in federal criminal cases, including public corruption matters, for over 19 years. He's worked in the U.S. Attorney's Office here in West Palm Beach. During his tenure there, he was the lead prosecutor on cases against the Palm Beach County Housing Finance Authority with Lloyd Hasner, the Honest Services fraud cases with Palm Beach County, where he prosecuted Commissioners James Exline and Ray Liberti, and some other highly noted and profiled cases. In his private practice, Mr. Reinhardt represents public officials, lobbyists, and business organizations during federal public corruption hearings and investigations. Next to Mr. Reinhardt, we have Alan Johnson. Good morning. He is the Assistant State Attorney of the 15th Judicial Circuit, Senior Counsel for the state, working for attorney Michael McCullough in a newly designated public integrity unit. And finally, we have the honest services and public integrity from the business professional perspective from Bonnie Miskell, Esquire. She is a partner at the Boca Raton law firm of Siegel, Libman, Dunay, Shepard, and Miskell, and they assist clients to finance, structure, and entitle residential, commercial, and institutional real estate projects, as well as involved in other commercial endeavors related to this issue. With that, I will turn it over to our panel themselves to start their presentations. Do you have anything to add, Ann?
No.
Thank you all again for being here today, and we look forward to this very vital and timely information from these esteemed panelists. Thank you.
Thank
Garcia.
you. Thank you. My name is Rolando Garcia. I'm an assistant United States attorney. My title is Deputy Chief of the Criminal Division. One of my duties is to manage the West Palm Beach branch office of the United States Attorney's Office for the Southern District of Florida. I've been a federal prosecutor for 19 years. During that time, I've prosecuted many cases, a wide variety of cases, including many fraud cases. So I was asked here to talk about honest services fraud, which I hope you will see after I make my presentation, that honest services fraud is simply a fraud just like any other federal fraud case. There is nothing complex about it, and hopefully you will come to understand the law. Before I begin, I do have to make a quick disclaimer. Because of my position, I'm not allowed to give advisory opinions. And the agenda calls for questions from the audience. You may pose some questions to me, and although I would like to answer those questions, I'm just prohibited from doing so. It would be improper for me to answer those questions. So I will not answer them. And likewise, some answers from the rest of the panel may relate to hypothetical questions, and just because I don't answer or keep silent doesn't mean I necessarily agree with the other panelists. So let's talk about honest services fraud. Honest services fraud is found in Title 18 United States Code 1346. Honest services fraud is simply part of the federal fraud statutes that have been used for a number, many years, to prosecute thousands of individuals involved in fraudulent conduct. A fraud is a fraud is a fraud. All frauds involve the same or similar aspects to them. All frauds involve schemes involving deceit. All frauds are done by means of material misrepresentations or promises or omissions of material facts. The purpose and object of frauds generally is to unjustly enrich yourself. Most frauds are done for the purpose of financial gain. The manner and means by which frauds are undertaken varies on the type of fraud, whether it be an investment fraud, a consumer fraud, or an honest services fraud committed by a public servant. All frauds have three elements. Number one, a knowing and willful participation in a scheme to defraud, an intent to deceive or intent to defraud, and the use of the mails or some interstate wire communication to further the fraud. Now, most fraud cases, the issue and controversy, what a jury is asked to decide, revolves around the intent to defraud. Most defendants defend their actions by saying they didn't intend to defraud cases, whether it be an honest services fraud or it be a investment fraud. There is a peculiarity to the honest services fraud statute and law, because concealment of financial interest while acting on matters affecting their interest is proof of the intent to deceive. Multiple failures to disclose is even more probative proof of the intent to deceive or an intent to defraud. Now, you may ask yourself, well, why is that? If I conceal an interest, why is that evidence of my intent to defraud? Well, it's because the law says that public officials have an affirmative duty to disclose. You have a duty to open your mouth and speak up and make material disclosures of financial interest. You may ask yourself, well, why is that? Well, it's because public officials have a fiduciary duty, a fiduciary responsibility to the public. Just like a lawyer has a fiduciary duty to his client, a lawyer needs to disclose to the client any conflicts of interest he or she may have to the client that might affect his representation of the client. It's the same thing for public officials. You have a duty to disclose. You have an obligation to disclose. You have a fiduciary relationship with the public. Well, most honest services fraud typically occur in two ways. Number one, bribery. For example, where a legislator gets paid for a particular decision or action. And that's not very difficult to comprehend. The second way a honest services fraud is committed is by failure to disclose a conflict of interest during decision making. These obligations arise not only under state law, state ethical rules, where they may arise depending on if there is a rule on the conduct, but they always arise under the common law concept that public officials have a fiduciary obligation to the public they serve. It always arises. Now, there's also in a fraud case, really don't have to show economic harm. And especially in the honest services area, it's because the public nonetheless suffers a very great harm because of the crime. I want to give you an example of an honest services fraud prosecution. It's an interesting case, I think, for a number of reasons. It gives an indication of the conduct by the public official, which appears, you'll see, there are certain badges of fraud. His conduct doesn't look good. But the scheme itself is rather subtle. And there is no economic harm. Yet a jury found this individual guilty of honest services fraud, and the Court of Appeals affirmed the decision. Now, this is a case that occurred in Chicago. And it's called United States versus Bush. And Mr. Bush was a press secretary to the mayor of Chicago. Mr. Bush also owned a company that held an advertising contract at the city-managed O'Hare Airport. Bush concealed his ownership interest in the advertising company, telling his partner not to list his name on any documents submitted for the contract, and failing to disclose his interest on some financial disclosure forms. Money from the contract was paid through indirect channels to Bush, and Bush listed his stock holdings in the company and nominees' names. Well, there you see many instances of indications of an intent to defraud. He's not filing disclosure forms. He's not on the company. His name's not on the company. He's getting money funneled through him through back channels, and he's utilizing nominees. Now, what Bush does is he introduces his partner to city officials who would determine the contract, and he vouched for his partners as reliable, capable, and experienced. Bush, however, failed to disclose his financial stake in getting the contract. Bush never specifically requested that the contract be awarded to his company, and he never asked for any special treatment. The city also made no complaints about the contract or the company's performance. The Seventh Circuit Court of Appeals upheld Bush's conviction despite there being no concrete evidence of extortion, bribery, kickbacks, or a violation of any law other than the mail fraud law, the honest services law. Criminal liability instead was based on the totality of Bush's actions, demonstrating that he engaged in a conscious effort to hide his private financial interest in public contracts and that he was acting upon in his public position. While recognizing the subtlety of Bush's scheme, the Court of Appeals affirmed that Bush defrauded Chicago, its government, and its citizens through fraudulent pretenses by collecting his city salary and his hidden profits from the airport contract. The court stated, "We think that Bush did more than breach his fiduciary duty. He materially misrepresented his interest. Bush was not making his recommendation merely as a disinterested public servant. His ownership of the ad company was material to the city's officials' evaluation of Bush's opinion of the company, which he was recommending. Moreover, Bush's statement that the company was reputable without disclosing that it was the device by which the mayor's press secretary secretly derived profits from a city contract was itself a material misrepresentation. The information concealed by Bush was material to decisions as to whether to award the contract to Bush's company, and if so, at what price. Bush's claim that he did not engage in fraud because he did not personally award the contract was irrelevant because, as the court states, he used his official position within the mayor's inner circle to exert the substantial influence which he had on those who were responsible for negotiating the contract. He did so without advising them that he was vitally interested in the contract or that his sole responsibility under the terms of the contract was to promote it. After the contract was awarded, Bush took steps to ensure that the proceeds of the venture could not be traced to him. He misrepresented his interests to assist in assuring the contract would be renewed and filed false documents to continue his employment. The fact that the city did not lose money on the contract and that, in fact, it was, quote unquote, one of the best in the country was similarly irrelevant. Because they had the city known of Bush's interest, it might have been able to obtain a better contract or negotiated a contract that might have earned profits for the city. Thus, the deal may have been a good one for the city. The problem is that Bush deprived the city of its officials of making a better deal or the best deal possible in order that he might share in the profits. Materiality also becomes an issue sometimes in honest services fraud type cases or any fraud cases. For example, a public official might receive some gratuities, a trip somewhere, some other financial benefit that in and of itself may not appear to be a big deal for the public official because of the nominal nature of the gift or the financial interest. However, do public officials want to take that chance? My guess is no. So what should they do? Disclose, disclose, disclose. Go seek the advice of your counsel, especially if these gifts or what have you are done on multiple occasions. As I stated before, the law is clear on hidden financial interest. That's probative evidence of an intent to defraud. So why take the chance? Simply disclose, go seek the advice of counsel. Now, I want to leave you with one final thought. There is conduct that perhaps may be viewed as unethical, but that conduct may not rise to the level of justifying a federal prosecution for honest services fraud. However, if the goal is to create confidence by the public in its public servants, then the appearance of impropriety is as damaging as the impropriety itself. Thank you.
Thank you, Mr. Garcia. Now, Mr. Reinhardt, please.
Thank you. Some of what I'm going to say is going to overlap with what Mr. Garcia just said, but I think it's important to hear it as many times as you can because what he says is absolutely right. Based on some comments that were made to me before the panel started today, I'm going to take one part of my presentation out of order. My sense is that a lot of you are here today because, as it was expressed to me, we're afraid we're going to do something by accident that gets us in trouble with the feds. How many people feel that way? Be honest. Okay. Let me give you one piece of good news. As Rolando explained, and as I'll talk about in more detail, you can't commit fraud by accident. Okay? Say it again. You can't commit fraud by accident. Okay? In order for it to be a criminal fraud, it has to be willful. Okay? And the essence of criminal fraud is intentionally deceiving somebody else. So, and I'm going to quote you from a Court of Appeals case where they said, even if a public official engages in, quote, reprehensible misconduct relating to an official position, he cannot be convicted of honest services fraud if he did not act willfully and with the intent to deceive. Okay, so you can't do it by accident. So I hope everyone will take a deep breath and exhale, and I'll get on with the rest of my presentation. Let me talk for a second about honest services fraud in a slightly larger context. You as public officials and public servants interact with the public. You interact with business, and Bonnie is going to talk about the specifics of that and some of the issues that come up in interacting with businesses. What's important to recognize is there is a whole universe of contacts that can occur between the public and their government. And they fall along kind of a spectrum of activity. I like to think at one end you have constituent service. That's what public officials are there for. Right? If you have a pothole in your neighborhood, if you have a feeling about a public issue and you want to call your representative, that's what the First Amendment says you're supposed to do. That's why they're there. So I don't think anyone would argue that legitimate constituent service is problematic. There's fundraising. Well, the law says you can raise money if you want to run for office, and the law says that you can give people money to support them if they're running for office. And I think Al's going to talk a little bit about some of the state laws that limit that, and there's certainly limitations on legitimate fundraising, but within the bounds of that, there's nothing wrong with fundraising either. There's activity that some from the outside might construe as what the Supreme Court said in the case, the rough and tumble of politics. You know, politics isn't always pretty, and there's some hardball political conduct that goes on, and that's just part of a democratic system. But you don't have to like it. It's not pretty. We don't necessarily like to think that our public officials do it, but it's a reality. And there's nothing wrong with that either. Okay? There's things that we might look at from the outside and say, that smells, I think that's sleazy, I think it's horrible, but again, it's not illegal. And I think that's a little bit of what Mr. Garcia was talking about. Maybe unethical in your own personal moral code, it may be horrifying, but it's not necessarily illegal. The reason I go through all that is what can be and is prosecuted as fraud, as criminal frauds, and also under some other federal statutes involving state and local corruption that we're not going to talk about today, is a very small part of what the public does when it interacts with its government. And you and the people who serve like you in the public, as our moderator said, you go to work every day to be honest and provide good services to your constituents and to do your job honestly and fairly and to treat everyone well and not to break the law. Okay? And we have had some situations here, unfortunately, where people didn't do that. And unfortunately, that's what gets press. That's what gets the attention of everyone when they look at our county. It's not the 99+% of people who are honest and the business, like the tax collector's office, that is conducted honestly and ethically and fairly. It's the others. So I just want to make that point. It's a very small part of what you do every day, and honestly, based on your good common sense and your good sense of judgment, most of you go to work every day and don't get close to the line. So again, I think you can exhale a little bit on that. Let me talk a little bit about the background and the theory behind why Congress enacted the Honest Services Fraud Statute. It started really back in the 1960s because there was a perception that state and local prosecutors wouldn't take it seriously to prosecute other people who were maybe political allies or otherwise involved in local politics. And the feeling at the federal level became that the federal government needed to develop tools to prosecute state and local corruption. And there are a limited number of federal statutes that allow you to do that. And at the time, some bright young lawyer in Washington came up with the idea of prosecuting cases under an honest services fraud theory. And there's a long history to it, which I'm not going to get into. But the end result is Congress did enact a statute in 1987, which Rolando talked about, that codifies what is an honest services fraud. And it is now the law of the land that you cannot engage in this activity. The goal behind this law is transparency in government. It's as simple as that. It really focuses on the processes of government have to be fair to everybody and have to be open to the public and open to the other people involved in the political process. Another court said, public officials may legitimately disagree over which of many competing interests in society deserve their support. But without transparency, the public cannot evaluate the motivations of public officials who are purporting to act for the common good to determine whether they are in fact acting for the common good. And to that point, again, transparency is the goal here. That's why the statute exists. And I agree 100% with the previous speaker. Disclosure is good for the soul. Okay? The more you disclose, the less you can get in trouble for. And frankly, if you're afraid to disclose it, you probably shouldn't do it anyway. It's as simple as that. You know, if you're not proud to stand out in front and say it, you probably shouldn't do it. I'm going to talk for a second about it was mentioned that I was the prosecutor on the case involving the Housing Finance Authority and Lloyd Hasner. And I don't bring this up in any way to pick on Mr. Hasner. He's always been a gentleman to me, and I think he's a fine man. But I do want to talk about the case as a representative sampling of something. What happened in that case was that he was going to receive an undisclosed commission on a real estate deal that was being financed by the Housing Finance Authority. I'm going to simplify it a little bit. He recused himself from the vote. He did not vote. But he also didn't disclose why he wasn't voting. Okay? He then, when an issue was raised as to whether anyone had any interest in the transaction, he said he didn't. He was prosecuted for honest services fraud and was convicted. He didn't even commit any official act. He didn't vote. And that was the defense at trial. How can you commit a fraud when I didn't vote? Well, the theory and the conclusion was, by not disclosing his interest, the other members of the authority made a decision based on flawed information. If that had been honestly disclosed, they may not have voted for the project. They may have structured the project differently. And that's when I talk about transparency. That's the theory here. If you've got a secret hidden interest in something that's come before you and you don't tell everybody, then other people are going to act differently than they would if they knew the truth. And so that's the theory here. That's what we need to do. All right, so what are some tips to stay as far away from the line as you can? With all due respect to the fellow who wrote all those books, everything you need to know about how to stay away from honest services fraud, you learned in kindergarten, okay? The first thing is the obvious. You don't lie to people. A lot of times, Rolando was talking about the badges of fraud, the conduct that tends to show that you were acting willfully as opposed to accidentally or innocently. Well, when you lie about it, when you're asked about it, it suggests that you did it for the wrong reason. It's as simple as that. Okay? It also opens you up to a new charge of obstruction of justice, which is a lot easier to prove than honest services fraud. But the point is, don't lie about things. Okay? Another one, don't take candy from strangers. Okay. Right? What the tax collector was talking about. If someone comes in your office and wants to give you lunch for free, you have to wonder why they want to do that. Okay, and if it's not someone who you know and you know they're giving it to you because they really are your friend, and they're someone you trust and you have an existing relationship that's independent of your official position, don't take it. It's as simple as that. Don't take candy from strangers. Another one is stop and look and listen. You all have a good moral compass. You know, when you read about the cases that have been in the paper, the cases that Rolando talked about, the Hasner case, there's conduct in those cases that everyone should look at and go, people shouldn't do that. You know, you shouldn't hide your financial interest. You shouldn't take a bribe. You shouldn't lie, things of that nature. If you start to feel your antennas go up, that something is drifting in an area that you're just not comfortable with, and maybe someone's demanding something of you that doesn't feel right. Maybe they're offering you something that you're uncomfortable that they're offering to you, stop, look, and listen. Go find someone else to give you advice. Make sure before you move forward that you're not setting yourself up for something problematic. And a lot of these cases, when you look at them, are what we call situational frauds. They're people who, in their careers and in their lives, have been honest and will be honest and are inclined to be honest all the time. But they find themselves in a position, they make a snap judgment because they're under pressure. Maybe there's a client pressuring them to do something. Maybe there's a public official who has a lot of power who's pressuring them to do something, and they do it. And if they stopped and thought about it for an hour, they'd never do it. But they do. You got to stop when your antennas go up. You have to tattle on people. I'm sorry. You have to tattle. If someone offers you something that you shouldn't be offered, if someone demands something they shouldn't be demanding, if someone wants to hide something they shouldn't be hiding, you need to tell on them. I'm sorry. You know, you need to disclose that. Otherwise, if you don't, what happens? It comes out later that you knew about it and you didn't disclose it, and now that's another badge of potential fraud where people look at you and say, well, if you knew about it, why didn't you say something? Well, the reason you didn't say something, of course, must be because you were involved, and now you're going down that slippery slope into something you don't want to be into. So tattle on other people. And the last one is, when in doubt, ask a grown-up. Okay? There is, I will say this not just for business development reasons. There is one absolute defense to fraud. That is, I went to a competent lawyer, I disclosed truthfully all the facts to that lawyer, and the lawyer told me it was okay. That is an absolute 100% defense to a fraud. Okay? The lawyer could be completely wrong, But if you told them the truth and they were a competent lawyer to provide that information, then you're protected. So when in doubt, go ask a grown-up. When I was a young prosecutor 20 years ago, I got the best piece of ethical advice from an old-timer who was my boss at the time. And he said to me, if you want to stay away from the ethical line, it's real simple. You apply the mother rule. I said, well, Lee, what's the mother rule? He said, the rule is you never do anything you'd be embarrassed to tell your mother. And you know what? That's true. If you look at all these cases that have come out in our county and elsewhere around the country, nobody would want to tell their mother they did that. So apply that rule. So where do we go from here? First of all, I really do honestly want to applaud both the League and the tax collector for sponsoring today's event. I think it is a tremendous start to a dialogue that is long overdue. It's been said that people get the government that they deserve. We in Palm Beach County deserve a government that's honest and open and fair. And we need to start a process to get there and to make sure, more importantly, that everybody knows we're getting there. One of the frustrations is right now that people feel there are no rules out there. There's no guidance. And other than going out and asking a lawyer, how do I know what to do? And I know Leadership Palm Beach, I know the tax collector, I know the county. A lot of people are starting to try to put together guidelines and rules and bright lines for people, which is going to make things a lot easier. And that's an important process going forward, because without that kind of rules, people are adrift, people are scared. And more importantly, those lines between what's unethical and sleazy and criminal and these other things are very blurry. And so you're left in that blurry area, and you are delegating the right to decide where the line falls to the prosecutor, who carries the most severe sanction. And they're acting in tremendous good faith, and they're drawing the lines where they believe it's right, and where they believe it's legally right. But as a community, we can also draw some lines. Things are only unethical or illegal because we say so, right? There's nothing, you know, the law is a law because we decide that's what we're going to tolerate and that's what we're not going to tolerate. And we as a community need to step forward and develop some rules and some clear guidance about what we're going to tolerate and what we're not going to tolerate. And I personally look forward to being part of that. Thank you very much.
Thank you, Mr. Reinhardt. Now, Mr. Alan Johnson from the State Attorney's Office.
Thank you. First, I'd like to thank Ann Gannon for putting this shindig together, and I'd like to thank distinguished panelists for taking part, and welcome all of you, honored guests. The fact that you showed up today is a great, it's a great thing. It's 9 o'clock on a Friday morning. We have all these elected officials and public servants together in one room to learn. What are we here for? I'd like to start by saying that there's nothing more important to a free society than honest government, and I think you would all agree with me on that point. There's nothing more harmful to the effective and efficient work of government than the cynicism that comes from the public perception of corruption. When the public is not on your side, it is awfully hard to govern. Lately, we have been thunderstruck here in Palm Beach County with the length and the breadth. And I'm not just talking about honest services fraud prosecutions. I mean, I'm talking about the bookkeeper at the school, the police officer on the street, the person working in the office, and their boss, up through the electeds. Public integrity was the cornerstone of Michael McAuliffe's campaign, and there's a reason for that. It's because we need it. We need to be reminded of it. As a matter of fact, when Mr. McAuliffe was elected, he designated a new unit, a public integrity unit. Now, who am I? My name is Alan Johnson. I've been an assistant state attorney for 16 years. I came in with the Krischer administration back in 1993. For many years, I was a chief assistant state attorney under that administration. And Mr. McAuliffe felt that this issue was so important that he assigned a chief assistant state attorney to head as senior counsel a new public integrity unit. So it is a serious business, and we all hope that there can be some change in this public perception now. Now, change is a partnership. Okay, it's as a matter of fact, we appreciate, the state arm of prosecution appreciates the federal government coming in because nature abhors a vacuum. And I'll explain that in a little bit regarding the state resources and the state statutes. We need to get everybody's attention. And as I was saying, the state attorney's office wants to be a partner in this, not only for prosecution purposes. We live here. We have an open door. What we want, what we would like, is to be a part of a positive force. Nothing would make me happier than to run out of business. Now, what tools do we need? What tools do we have? What resources do we have? What resources do we need? What statutory changes? One of the things that we've introduced back to the state attorney's office is and I'm going to refer a couple of times to Mr. Reinhardt's eloquent words, tattling. Tattling is colloquial, of course, but we all know what it means, and we all know that it can be effective. If something bothers you, if something's wrong, just because you're not doing it doesn't mean that it shouldn't become public, or at least it shouldn't become, it shouldn't be stopped. We have whistleblower statutes in the state of Florida, similar statutes around the country to protect people who are in government from reprisals. We at the state attorney's office have a hotline, and it's an anonymous hotline. If you have your pens handy, 355-7491. That's the state attorney hotline. The website is PIU, Public Integrity Unit, PIU at SA15, state.fl.us. I would hope that it never would have to be used, but I hope it is used when it needs to be. Now, we're here for honest services discussion. This is a panel that's discussing what it is. Again, I hearken back to Mr. Reinhardt's eloquent words that, when in doubt, disclose. I mean, that's one major part of a fraud, is not disclosing. But the state statutes currently are minimal as regards corruption. Obviously, we have a general fraud statute, but the general fraud statute is akin to stealing. And there generally has to be an economic loss. There are theft statutes, and obviously that takes care of the bookkeepers and the people stealing directly from the state coffers. But aside from bribery, which requires a quid pro quo, and official misconduct, which essentially is falsification of records, which both, by the way, require what's called a corrupt intent. And a corrupt intent, according to state statute, corruptly or with corrupt intent means acting knowingly and dishonestly for a wrongful purpose. There are many actions that could not be prosecuted under the corrupt intent theory, because perhaps there is a failure to disclose, but there's no corruption there because it's actually good for the state, it's actually good for the municipality, there's no quid pro quo, there's nothing that's, there's no 60,000 frozen dollars in the freezer. So what happens with state ethics, codes, and laws? Well, the statute that governs it, you probably are all aware of 112. 112 is the Code of Ethics for public officers and employees in the state of Florida. Not one act specifically delineated in Chapter 112 is a crime in and of itself. Conflict of interest, nepotism, gratuity, or gifts that are not disclosed, those are all ethical violations, But in the state of Florida, by themselves, there's no, in that section, there is no criminal sanction. Now, each one of these ethical lapses could constitute a violation of the law under other sections of the statute. I mean, use of insider information, for example, that's a first-degree misdemeanor. Not a lot of teeth in a first-degree misdemeanor. And in candid conversations with elected officials and staffers, one of the problems that we've had in Palm Beach County is that public officials, well, you know, if I don't disclose this, you know, I might get fined if they catch me. And until the federal government came into the breach, this probably was a common thought process. When people, well, it's just $150, it's a round of golf, it's a night at a hotel, what's the diff? And people were not taking this seriously. That's a shame, and that's a problem. And we got to the place we are today because ethics were not being taken seriously in our county and our state, I might add. Now, we do not in the state of Florida have statutes dealing directly with gratuity or conflicts of interest. I talked about conflict of interest, gratuities as well. Federal statutes do. They're directly on point, and they're felonies. And as I said, nature abhors a vacuum. Now, there's a new bill filed, I think just this week, in the legislature. It's 838.23. The significance of the fact that it's filed under 838, see, 838 is the bribery and misuse of public office statute. It's not filed as the federal statute honest services fraud in conjunction with schemes to defraud, which is a artificer scheme to defraud under the basic telecommunications theory. 838.23 defines theft or deprivation of honest services. A person, including a public servant, may not engage in a scheme or artifice to deprive another of the intangible right of honest services or any activity in contravention of his or her commitment to provide loyal services or honest governance for the residents of this state or a local government within the state. This section shall be construed to the extent possible in accordance with the standards and intents set forth under 18 U.S.C. 1346, which is the one-line honest services artifice to defraud. That's a third-degree felony, which also is a less severe sanction than exists in the realm of the federal statutes or the federal arm. It says this act shall take effect October 1st, 2009. Of course, it needs to be passed by both houses of the legislature. So right now, we don't have an honest services fraud in the state of Florida. Now, where does that leave us? I mean, what we're dealing with here, and many of you showed up, and I'll be candid, and you should be candid too, out of fear. I think you answered that question. How many people are, want to, are afraid? And fear is an effective motivator, for sure. That'll get people's attention. But we cannot legislate, we cannot prosecute our way out of what is essentially a moral dilemma. And I agree again, I'm going to hearken back to Mr. Reinhardt's eloquent words about kindergarten. And in fact, there was an FAU section that's been opened on public integrity. They're a wing, a course of study at the Florida Atlantic University, and they had a big splash. And if you got to teach ethics at the college level, let alone your professional levels, we are in some serious trouble. And I do agree, and I think that if at all possible, more ethical treatment should be had in K through 12. There should be a little more of that. But again, education is necessary, but common sense is essential. And again, Mr. Reinhardt, I quote, "Don't take candy from strangers," and I'd like to add, or friends. And Mr. Reinhardt, unless you are willing to tell your mom, and I would add to that, unless you are willing to tell the world. Because literally, if you feel even an inch of angst about telling everybody, we say in the prosecution business, when we're speaking or we're out in public, would you like to see these words tomorrow on the front page? Would you like to see these words broadcast to the world? If you have even an inkling of doubt, then don't do it. And again, I'd like to say nothing would make me more happier, more, well, inartfully structured, but make me happier than to run out of business and to go back to prosecuting homicides. So hopefully this message will get out, and we can improve the image of Palm Beach County, the image of good governance, and we can do that together, interagency, different arms of law enforcement, the defense bar as well. We need to do this together. We've crawled into this hole from years and years and years of neglect, and we're going to have to get out of it together. Thank you.
Thank you very much, Mr. Johnson. Now with our final prepared presentation on honest services and public integrity from the business professional point of view, Bonnie Miskol, please.
Thank you again, Ann and Jamie. This is wonderful. I appreciate being here. I'm honored to speak to each of you today. First of all, I neither prosecute nor defend on the basis of honest service fraud, and I hope that I'm never on the other side of the table from these gentlemen here or have to hire Bruce in any event. But I'm here, my perspective is a little different. I am a licensed attorney, licensed in the state of Florida. I've been practicing for approximately 18 years, actually. For that entire period, I have specialized in assisting both private and public sector as it relates to entitlements for the most part. I see many of you in the audience that I have presented before. It's nice to see you. I have never taken any of those people out to dinner or lunch. I want to say that. In any event, it's my job to take the law, evaluate the law as it relates to my clients' projects, and convince the elected officials that I present to that it is in the best interests of the public. And I come up on each side of the equation sometimes. I'm pleased to say more in favor than against, because when we look at a project and we evaluate it, we look at the merits and see if in fact, you know, we could stand before our children, who I happen to have 3 kids, and be proud that I presented and supported that particular project. Having said that, I was pleased when Ann called me, because many years ago I did a little research on this topic and was very surprised by the results of the research. There are many, many dozens and dozens of cases out there as it relates to honest services fraud. I am far from an expert on them, but I found all of them very interesting. What I did find is that the courts are scattered and across the board in interpreting and applying the rules. You know, I do agree with my colleagues here that if the feeling is there's something wrong with what I might be doing, then you probably shouldn't do it. But there are some cases out there that would surprise you. And I'll go into that in a little bit further, I'll elaborate a little further. But particularly I'd like to talk to, and I know most of you are public sector here, but I'd like to speak to lobbyists. Part of what I do would qualify under most jurisdictions as a lobbyist. It's not all that I do, but it's part of what I do. A lobbyist is retained to influence those that they're presenting to. If they don't really have influence or access, it's very unlikely that they'd be hired. When my clients come to me, I either have worked in the jurisdiction or I have not. If I have not, it's not likely that I'm necessarily the best person for the job. I don't necessarily know that jurisdiction very well. I don't necessarily apply those laws very well. And to be honest, I'd be candid with my client and I'd advise them of that. In the cases where I am comfortable, where I do know the law, I have practice, I've submitted applications, I've done the research, those are the cases that I'm prepared to take. Now, just because I'm a lobbyist doesn't mean that I necessarily have the same level of influence as the next person, but influence is what the developer and the client think they're getting. Whether that's right or wrong, it is the case. I'm going to talk a little bit about a case that is probably one of the most widely publicized cases as it relates to lobbyists. And by the way, a lobbyist is not necessarily a lawyer. I happen to be. So there are a whole group of ethical rules that apply to me that don't necessarily apply to others that are not lawyers in the state of Florida or other states. But the case I wanted to talk a little bit about is one extreme, and that's the Jack Abramoff case, which I'm sure many of you have read about. For those of you that aren't so familiar with the facts, I'd like to talk a little bit about it. On January 3rd, 2006, Jack Abramoff, a highly influential and very well-connected lobbyist, pleaded guilty to conspiracy, honest services fraud, and mail fraud and tax evasion. The honest services claim was really threefold and kind of interesting because you don't hear about some of the bits and pieces of it. The first claim was with respect to his clients, related to using his influence with his clients, and specifically he had 4 Native American tribe clients that he was representing from 1994, I think, to 2004. For the most part, the representation was in connection with legislation associated with limiting the competition as it relates to gaming matters. There was another part of it as it relates to the Texas Native American tribe, where he had agreed to represent them for free. In exchange, however, he used his influence to suggest and recommend that they hire a company or a consulting group that offered them both grassroots and PR work. What he did not disclose is that he had a significant financial interest in that and obtained 50% of the fee as a result of that. So there was non-disclosure. While he was representing this particular tribe for free, he also was representing a Louisiana tribe in connection with opposing what he was allegedly doing for the Texas tribe. He was trying to reactivate a license to reopen a gaming facility. So one of the claims was based on that deception. Also, which isn't necessarily the public component of it, Abramoff had been hired by a wireless telephone company, and he convinced them actually not to officially hire him in his capacity with the law firm, but with another nonprofit company that he had set up. They paid the nonprofit company, thereby depriving the law firm of the fees that the cell phone company had originally intended to hire. So then there was, again, he defrauded his employer by deceitful behavior, and we can go a little bit more into that if you have questions. And then the third part of it was just public corruption. And associated with the public corruption, I think, and this is the extreme, there were very, very lavish expenditures, trips to Scotland for golf, lavish dinners, all expense-paid travel, and many other bonuses and payments that were made in order to influence legislators and their staff. And that was the third component of the honest services fraud. Again, most of the expenditures that made were very, very lavish. However, it's interesting to note that noted in the Justice Department's report and findings, they included references to campaign contributions, lunches, and expenditures that aren't lavish, that truthfully you hear about and you see and very well may know of. So I think that's where what would otherwise seem to be pretty black and white gets a little gray. I'm not going to go into the tax evasion part of it, but you know, there were also other charges associated with that. As a result of that particular case, at least 12, and I think even one last month, other people have been charged and have either pleaded guilty or are being investigated as we speak, all related to Abramoff's scheme, and which was far more complex than some of the local cases that we have experienced in Palm Beach County. What I'd also like to note, we think of, and I think because it is more news noteworthy, we really look at the honest services fraud as it relates to the public sector. We don't look at the private sector. But there also is a lot of case law out there that relates to companies, Enron I'll use as an example, and others, insurance agents, et cetera. There are also some cases that don't rise to the level of an Abramoff that I think are worth talking about when you ask yourself, well, what constitutes, a case here? What can I do and feel comfortable that I'm, that I'm not going to accidentally fall into this mess? And there's one case that I did want to talk about. It is United States versus Thompson. It's a Seventh Circuit case. And this one I found very interesting because the actions and the activity would seem quite reasonable and almost unbelievable that there would be that a person could be found guilty of the honest service fraud. But this was a case in Wisconsin, a public servant whose job was procurement. They were responsible for processing a particular selection of the travel agent for the state. And in that case, during the bid process, 2 travel agents were identified, shortlisted, so to speak. One was out of state, one was in state. This particular department chief, after seeing the outcome of the selection committee, decided to delay awarding that particular contract. And after going back to the selection committee, convinced the committee that it was appropriate perhaps to reevaluate it. They did, and well, before I get there, the out-of-state travel agent was going to be awarded the contract. The chief had a problem with that. They went back to the selection committee reevaluated it, and then they decided upon, after again, a bidding kind of process, changed their decision and went with the in-state travel agent. That chief was charged and found guilty by the circuit court, or I'm sorry, by the lower court. They later overturned that decision, but what was at issue in that particular case was that within a few months after the chief changed the process, so to speak, slightly to reevaluate the awarding of the bid, the chief was given a raise. It was a $1,000 raise, and it was on that basis that the person was ultimately charged. The court in this case, though, did overturn and had concluded that the employee was, in fact, looking out for the public interest. That employee believed that it was in the state's best interest to have a state travel agent, someone that was located within their border, who was, a citizen, so to speak, of the state. So the court felt that it was, in fact, in the public interest, and a person cannot be held accountable under the honest service fraud on that basis. But, usually the cases are more like the Abramoffs, where you have lavish gifts, you have monetary value that is significant. But I just wanted to point out that one case, it was something as little as $1,000. So when you're looking at what I can do and what I can't do, I'm of the opinion that err on the side of being conservative. If you don't put yourself in a position where it might look bad, then just don't do it. I, as a practice, as a lobbyist, I do not take people out to lunches other than my friends and family. I do not buy gifts. It's very easy. When I go into a jurisdiction, I know what that jurisdiction's laws are. If you don't have laws on your books right now as it relates to registration of lobbyists, or for that matter, annual reporting, I would encourage you to do so. Most jurisdictions do today. Those lobbyists need to follow the laws. You need to know them when you go into the jurisdiction. If they require you to register, by all means, do register. If they require you to report on an annual basis, even if you have nothing to report, report. Some jurisdictions impose penalties if you don't follow the rules, financial, monetary, and even can ban you from presenting. I encourage you all to look at that if it makes you feel more comfortable. You know, rules are important. They're great. They allow people like me and others that do what I do to know what we have to do to stay within the confines of the law and for it to be, to look good. We don't want to make the elected officials or the staff members that we speak to look bad. We want to follow the laws. So we appreciate it when you enforce your own and you have them in place so that it's something that we can follow. I think we've gone over our limit, actually, and yes. I will turn the microphone back to our host, but thank you for your attention.
Thank you very much, Bonnie. And thank you to all our panelists for your very pertinent and timely presentations. I believe our next phase is questions from the audience, and I will defer to the tax collector, Ms. Gannon, to lead in with the first question.
Thank you, Jamie. And if you'll bear with us, we do have a number of questions, and there's some elements that are the same in them, and we may not get to all of these questions, but hopefully you have an opportunity to submit them. We will keep them, and if you've signed it, we will try and get an answer to it and get back to you. So bear with us because we only have this chamber to 11 o'clock. So let me start with a question that is really a pretty a personal opinion of all of you, I believe, but what causes greater harm to society, drug dealers or corrupt officials? Anybody want to take it?
No? I'll go out on a limb, corrupt officials.
I agree. I agree. I think...
Go ahead if you want to expand.
You expect your public officials to act well. You don't expect your drug dealers to.
It's true.
It's like the teacher or the policeman. It's a higher standard.
It is. It is.
Okay, this one I will throw out. This has to do with the relationship between municipal elected officials and their staffs and infrastructure. Does a municipal elected official need to disclose pertinent conversations on agenda items with municipal employees, i.e. with the town manager or the town planning director or any other person in charge of the various projects?
Well, that leaves two panelists to discourse on that because I think that Mr. Garcia and I are not going to comment on that hypothetical.
Oh, I'll jump in here. Most jurisdictions have adopted, I think one of the questions is, does that qualify as ex parte communications? And I would encourage you to go to your city attorney or your county attorney to give you advice on that. But there has been at least one jurisdiction that has advised, and not as it relates to your internal staff, but as it relates to department heads, to treat that as if it's an ex parte communication. I've heard one city attorney say that. Whether that is legally sufficient or not, I'm not going to opine to that. But, again, where there is doubt, then err on the side of being conservative and disclose the information that has been provided to you so that the public knows how you're basing your decision and your decision can then be justified.
I think it depends a lot on what the conversation is. I mean, if it's just a conversation on the merits between a staff member and an elected official, I think it's different than if the staffer says, I got a call today from Bonnie Miskell, she represents XYZ Corporation, and they want to be sure you know, blah, blah, blah. So I think it really turns on what the substance of the conversation is, and as Rolando said before, whether it's material, whatever that means, to the decision that's being made.
Thank you.
Where charity is the only beneficiary of an action or result, does this impact the honest services fraud analysis?
No.
Thank you.
And I will tell you there are other federal statutes to which it also is not a defense. Just because you extorted somebody for a good purpose, it's still an extortion.
Okay, thank you. I think, Mr. Reinhardt, this also addresses one of your earlier comments. How would a lawyer, an attorney, know if everything that's being disclosed to them is everything, is the full story, and then isn't a legal opinion to bless that behavior. Who becomes liable in that situation you were referring to?
Oh, the client. I mean, you presumably, if you've come to see Bonnie or you've come to see me or some other lawyer to get a legal opinion, you want an accurate opinion. And certainly we would ask you the necessary questions to try to get all the facts that we need to have. But if you affirmatively lie to your lawyer or you hold something back, it's not just that you're liable, that actually defeats the purpose of seeing them. And as a legal matter, it defeats your defense. I mean, when I used to prosecute, if someone asserts an advice of counsel defense, the first thing you try to figure out is what didn't they tell their lawyer? So you're shooting yourself in the foot if you bother to go see a lawyer and then you don't tell them everything. How about your clients, Bonnie?
Clearly, if the client is not giving you the true story or the full story, then the opinion you give them is based on the facts they presented. So it isn't worth much more than that. There is really no value in presenting your case to a lawyer when you're not giving them the details that they need.
Can I raise one? Okay.
Yeah, absolutely. I mean, I've been doing this a long time, and I've never seen, perhaps there are cases out there, but I have never seen an advice of counsel defense work. Because what happens is the defendant doesn't make full disclosure to the client or to the attorney. Because if the defendant does, the attorney's he knows the law or she knows the law and advise the client accordingly. That's a crime.
If I can just go a little off the center of that topic, though, this is not something that many of you should be unfamiliar with. I mean, for example, when you do a bond closing, you have to get an opinion from the bond lawyer that everything is proper. And there are all sorts of other commercial transactions where people will not close the transaction without having an opinion letter from a lawyer saying whatever rule has been complied with. And maybe this is something we should all think about. We don't require an ethics opinion. Maybe we should.
I'm sorry, go ahead, Alan.
One thing to add is, do you really want to entrust to a third party their memory of the events and the facts that you give them? If something is wrong, it's wrong. And just disclosing it to an attorney with the idea of getting around the legal or obtaining a legal defense, you're still putting yourself on the line if that attorney either does not remember or did not write down or is not forthcoming with the facts that you believe you told that lawyer. So what's wrong is wrong. And that introduces, again, the concept of common sense.
The disadvantage that you are at, if an attorney has a question about the laws or the rules of ethics, we can contact the Florida Bar and ask the question and have some comfort that what they're sharing with us allows us to reasonably rely on it. You're at a little different disadvantage because there is no such body as it relates to this. So, and again, when, just as Bruce mentioned, when we give opinions about a lot of things, whether you're bond counsel or real estate counsel, but we're able to, number one, look at the law and then evaluate the facts that are of record. Unfortunately, in a case like this, the facts are not of record, so it's not like the lawyer would otherwise know what was going on without you disclosing. So,
one addition. There is for public officials the specter of going to the Attorney General for an Attorney General opinion. It does take time, but there's a wealth of Attorney General opinions, and in which case it's all out in the sunshine because the request is made, the facts are laid out, the opinion comes in based on all written data. That's
correct. Thank you. Public officials are being convicted and punished under honest services. Private sector walks without any punishment. I'm not quite sure that's 100% true. What laws, if any, would allow you to go after those who fund and benefit from the breach of public trust? And to truly change ethical culture, both sides need to be held accountable. Would anyone care to comment?
I may not be understanding the question correctly, but people in the private sector are prosecuted all the time for under the federal fraud laws. It's equally a crime to defraud somebody if you're in the private sector, and we do that all the time.
You know, the problem, Ann, is that they are usually not the cases that are so noteworthy. So the news doesn't necessarily report it because it's just not interesting. It's much more interesting when it's an elected official or someone that is of notable or noteworthy or newsworthy discussion.
And I think that in the cases that have come before the federal prosecutors, in fact, there have been people from the private sector that were prosecuted and have spent some time in the the penitentiary or the federal hotel that you all send people to.
I mean, as a legal matter, I agree with Rolando. The willing payor or giver of the benefit is equally liable criminally and can certainly be prosecuted as a co-conspirator or for participating in the same scheme to defraud as the public official. And that's where I go back to the point about you have to tattle, because you know the line between a willing bribe payer and an extortion victim can be very fuzzy. You know, if someone leans on you hard and you pay them, did you do it because you wanted to? Did you do it because you were extorted? You're better off to go and report that someone leaned on you for a payment, and now there's no question that you're an extortion victim. You're not a willing participant in the criminal activity.
Okay, this particular question addresses the Sunshine Law, and it's a little lengthy, so I'll read it. Why the Florida Sunshine Law perhaps is defective? Why is it that it takes 2 or more public officials to meet privately to violate the Sunshine Law, when in fact most corruption activities may be enacted when one corrupt elected public official meets privately with one private citizen official or business person to do their business out of the sunshine, if you will. To correct the very serious problem, all meetings of public officials should be in the sunshine, especially if meetings with only one elected public official is involved with somebody soliciting financial benefit to himself or herself. Would you care to comment on that?
I know that there are some elected officials that feel that the law should be strengthened, the Sunshine Law should be strengthened, and that may be a laudable and a positive project. But the way the law was written and the way it reads, and the purpose of the law is specifically pointed to public officials that are on boards, commissions, that make decisions, municipal councils, etc. That is what the law was intended for, and it's the way it's written right now. So that 2 elected officials or 2 board members on a board that have a foreseeable issue that will come before the board don't get together privately to argue, discourse, make their decision, lobby to get something passed. So while that could be made, that could be codified regarding all meetings of a public official need to be, say, recorded, for example. That's not the way the law stands right now.
I'm sorry. If I'm talking too much, shut me up. It may, however, whether it's legal or not, you as public officials may choose to have a personal policy that you're not going to meet with certain categories of people by yourself. Have a staff member or someone else present to be a witness to what's being said, and then record whatever was said in writing if you need to, or ask the other person to put it in writing, because my guess is if they're not willing to write it down, they shouldn't be doing it anyway. So you can protect yourself, and you probably should, whether the law requires it or not.
Good point.
Actually, as someone who has met with many, many officials in both Palm Beach and Broward County, a number of the elected officials out there are doing that today. They're either recording every meeting or they have their assistants with them during the course of that meeting.
Thank you. Many public servants are also business owners. If a client or customer brings a land use change, for example, to the commission, what is the council person's responsibility? Is it simple disclosure? Is this business relationship a conflict of interest?
I'm not clear on what the business relationship was.
If you're a business person and also an elected official, and one of your clients brings an issue before the commission, should you just simply disclose it, or is it a conflict of interest, or what?
Well, I'll jump in here. If the elected official happens to be related to the business entity that's coming before you, then clearly they should recuse themselves, which I think all of you know that. And certain cases have found that it should even be disclosed further, not simply to recuse and not vote, but to disclose that whoever is before you is either related, they work for you, they're their business partner, et cetera.
Yeah, and I think if I gather the question correctly, they're also asking, what if a customer, for example, if one of my customers appears before the board that I sit on, not asking for anything relating to their business, but relating to something else or not anything I'm related to, the legal question would be, of course, is that material to the other members of the body? Was that something that might influence their decision on how to vote? And it can be very fact-specific. I mean, if I've had one business transaction with this person 5 years ago and we've never seen each other again, is that material? Probably not. If we have a regular ongoing business relationship and we do transactions all the time, it probably is. It's a good dose of common sense there, but what's the downside to disclosing it? Why would you not err on that side? The worst thing that will happen is people will say, who cares? But at least it's out there.
All right, I'll shift gears slightly, and maybe you guys can get back in the game here because it's a little different area. People are asking about Florida Statute 718 condominium law and board members, and they're asking to expand on some potential conflict of interest issues there. How does that differ from elected officials and what we're talking about here? Members that are appointed to condominium boards and those arenas.
I don't know.
I mean, I'll take a shot. I'll take a shot.
I don't remember the last state prosecution of a condominium board member that...
well, maybe just address the conflict of interest.
See, conflict of interest in the state of Florida is not a crime. Again, that is an ethical violation of Chapter 112. It can relate to a criminal activity if it becomes a fraud or some other statute. It may not, if it's not a public official or public servant, it won't come under the 838 statute. However, it may still constitute a fraud. Fraud is a fraud is a fraud. So disclosure, I mean, it's always a good thing. It's always a good thing.
We're here today to talk about public honest services fraud, and not to open a whole nother can of worms here, but there is a concept known as private sector honest services fraud, which may apply in that situation. If you're a condo board owner, you serve as a fiduciary for the members of the condominium association, and if you read Section 1346 in your spare time, it doesn't talk about a public official. It says to deprive another of the intangible right to honest services. So even in a private situation, there is a right, an intangible right to honest services. So if a condo board member engages in a scheme to defraud the condo members, and there's a mailing or a use of the wires, they very well could be prosecuted under the same statute we've been talking about.
On the federal side?
On the federal side.
I have a question about campaign contributions. There's a $500 maximum campaign contribution for a candidate in an election. Why is an individual allowed to contribute 10 or more $500 checks by 10 or more of his companies to one candidate in an election? Is this not circumventing the intent of the law?
Oh, I would not like to comment on a hypothetical. A lot of the election law is, in general terms, is again not criminalized. There is some criminalization of some of the campaign laws, like, for example, working out of your office and using state services and state related factors. But regarding campaign contributions, I'm not going to comment on that, but I do believe that it's not criminalized.
Right. I mean, this I think falls into that area of it may not be pretty and you may not like it, but the law allows it. And as opposed to what we've been talking about again, in the election finance area, there's a lot of guidance. There's lots of rules. There's lots of precedent. It's going to be very hard to stumble through that and claim you didn't really know what the rules are. And I think it might be a laudable goal for all of us that sometime in the near future, perhaps there be sufficiently clear goals in this area as there are in the election area. Again, you may not like the outcomes, but at least you know what the rules are.
There are also some municipalities that have further limited the amount that you are able to contribute in an election. I think Fort Lauderdale and Dania Beach and Broward have limited the amount to 250. So, you have other options in that regard. But as Bruce said, the law is the law. And although that particular issue has been somewhat controversial, it has not been controversial enough for our legislators to change it at this point.
And just so that I can make it known, there is a Florida statute regarding campaign contributions and limitations, but if it's allowed, it's allowed. And if bundling is allowed, which it is, I believe, then, but the statute goes, any person who knowingly and willfully makes or accepts more than one contribution in violation of subsection 1 of the contribution limitations, or subsection 5, fails or refuses to return any contribution as required in subsection 3, or aids and abets. It's a first-degree misdemeanor. Knowingly and willfully making or accepting 2 or more contributions in violation is a third-degree felony. So, I mean, there are some statutes on the books. There are loopholes, too.
Right, thank you. I actually have 2 questions that are kind of related, so I'll ask them together. If an elected official comes to the realization that they may be in violation of honest services fraud, either inadvertently or because they didn't know, what should they do? Should they turn themselves in? Should who should they consult? How should they handle that? And kind of related to that question, is there such thing as an I didn't know defense?
I'll answer the second one first. It depends what you claim you didn't know. I mean, it has to be willful. You have to know that what you're doing is improper. You don't necessarily have to know what law you're violating, but you have to know you're doing something wrong. So it really depends on what you claim you didn't know. More likely, the defenses arise in situations where you say, well, I have a legitimate long-time personal relationship with this person. We vacation together, and they go to my house and I go to their house. And so when they gave me my Christmas present, I didn't think it had anything to do with the fact that they were also seeking some favor from me in my official position. Again, why you wouldn't just disclose that and otherwise put yourself at risk is the open question. As to the first half of that, I'd like to say they should call me.
Which is one of the reasons that Mr. Garcia and I will not comment.
Thanks. I have a question about the FRS system, and I'm not sure you're the appropriate body to even discuss this issue, but I will give it to you and you can give us some feedback on it. Under Article 5 in the statute and penalties, the Florida Commission on Ethics, the felony convictions, forfeiture of retirement benefits. If a person is already retired in the FRS system and then becomes an elected official and is convicted of certain offenses while in office, does this affect his retirement? Since he or she really has 2 different issues. Would you care to comment?
That's a direct, specific hypothetical that I will not comment on.
Well, and I think that the attorneys that are prosecuting the case are really not involved in that decision. That's really another body who would make that decision.
And Mr. Reinhardt, I hope you brought a big stack of business cards for all these hypotheticals.
Happily did, yes.
If the law requires that a public official vote on all matters unless there is a personal financial gain or interest, how does a public official handle it when a very close friend, personal friend, comes before the board on any matter, and for whatever reason that official might rather not vote? How do they handle these situations where there may not be a financial gain or direct interest, but it is a very close friend?
Never heard of that.
I'm not aware. Are there really such ordinances that require you to vote in those
Yes.
situations?
Yes.
I mean, if someone came to me and asked me what to do, I think all you can do is disclose it. And from a criminal perspective, that's all you can do. And say, I'd rather not vote, but I have to, and then do the vote that you think is right.
What I've seen out there where this actually is something that happens, I have seen the elected officials disclose the relationship, that they're a long-standing friend. I have no personal or financial interest in this matter. There's no personal gain associated with that, and they voted. But again, there's disclosure that they have no interest, and they've also disclosed that the person is a friend. I mean, the reality is that, yes, you're an elected official, but you're also a human being. You have friends, you have family, you have relatives. And there are certain things that are just not illegal, although there may be improprieties or appearances. But if it's not illegal, it's not illegal.
I'm going to tell a very brief story of my first trial in Palm Beach County, and this will illustrate the point. And this is a true story. I came here in 1993. My family came a month later, so for that 1 month, I lived with my law school roommate who happened to be a judge. So happens that my first jury that I picked as a rookie prosecutor was in front of this particular judge. And I also knew the defense attorney, who was a friend of the judge as well. So before the trial began, the judge said, I need to make a disclosure. I went to law school with the prosecutor. And remember, I'm a rookie. What I knew was not much at that point about trial work and criminal law. That's my disclosure today. And the judge made that statement, and the seasoned defense attorney said, "We waive." And then the judge said, and as a matter of fact, we were roommates, the prosecutor and I, in law school. Without batting an eye, the seasoned defense attorney said, "We waive any conflict." And then he said, as a matter of fact, the prosecutor, until his family arrives, is living in my house, in my guest room. The seasoned defense attorney said, "Your Honor, we waive." And the client at this point is looking at his defense attorney like, wait a minute. And then the judge said, as a matter of fact, the prosecutor and I drove here to the courthouse this morning, and I'll be driving him home tonight. And again, Your Honor, we waive, because he was comfortable with me prosecuting the case, but it was all out there. Even though the client was scratching his head, the lawyer made that decision, and it worked out for all parties. The case actually settled. But that illustrates the point. You got to say what it is that's on your mind. Use your common sense in all circumstances. The things that you hold back are the things that'll hurt you. Even if the first one doesn't, even if the second one doesn't, eventually it will. And that's what ethics are all about.
And just to add, by the way, if you happen to be on a board or a commission or council where you have an attorney present, you can always seek the advice of your counsel. That's another way for you to feel a little bit more comfortable in your disclosure.
I think that you all covered this issue, but if you would go over this again. The question is regarding knowledge of a honest services crime, and wondering if they can be prosecuted, and what's the process once you become knowledgeable about that crime. And I actually think you went over this previously.
I mean, someone's raising their hand.
That's my question. I'm not interested in the process. I just
Oh,
The mail fraud statutes?
You have to take the affirmative act to.
Right. I mean, there is a federal statute. I was consulting my former boss here. There is a federal statute called misprison of a felony. And that is if you are aware of a felony having been committed and you take some affirmative act to conceal it, you've now committed a new crime.
And in the state's system, it's called aiding and abetting after the fact.
thank you.
I'm questionless.
Oh, okay. I actually have 2 questions. Will honest government include the Palm Beach County Sheriff's Office and the State Attorney's Office who investigate these agencies, an arm of the law who fails to uphold the law?
Is that a question?
Yes. I think what they're asking is, do you investigate the State Attorney's Office and the Sheriff's Office now?
Oh, internally.
Internally.
Okay. Well, I know that the Sheriff's Office has an internal affairs investigative unit, and they're very aggressive under Rick Bradshaw. I know that because I get the cases that come in, and they're well worked up, and they're seasoned detectives that are involved, and I would say that he has dedicated resources, serious resources, into cleaning up the perception within his office. As far as the State Attorney's Office is concerned, we've never had that issue come up where we've gotten a complaint about one of our own assistant state attorneys. But we have an investigative unit, but my feeling is that would be Florida Department of Law Enforcement or the Sheriff's Office. You know, I can't imagine a scenario where we would investigate one of our own prosecutors without outside assistance. For public perception,
right.
If nothing else.
Bonnie, this question is directed at you. You gave a procurement case example. Are there other issues surrounding procurement in terms of honest services?
Actually, there are many cases that relate to the awarding of a bid and contracts. And in fact, a claim where there was there's a case, and I can't remember the name of it, but it will come to me. And if anyone on the board remembers this case, jump right in. The employee actually was influenced by a bidder, but the bidder happened to be the lowest bidder. And their defense was, well, there was no harm because it was the lowest bidder. You would have selected them anyway. That doesn't matter. So there is a lot of law out there, and for any of you that would like to talk to me after the meeting, I'd be happy to forward some information to you so that you could read it yourself. But yes, that clearly is one of the areas that you have to be careful.
Thank you all. And I wanted to take this opportunity to thank our distinguished panelists for participating today and the audience for actually coming. And I hope that we've taken back a sense of where we need to go in our county. I'd like to thank my senior leadership team, in particular the staff of our communications and new media group in our office. And we would be glad to share with you our ethics policy. If you would like it, we would email it to you. But I think from this that there's a clear sense that people in our county, particularly elected officials and community groups, and the business community are interested in where the lines are drawn and what they can and cannot do. And as we say in our office, if there's a question, don't do it. And where we go from here, I think it depends on what we hear from the community. Now, my office would be glad to try and to start coordinating some of this, but frankly, it really has to come from the community and the Florida League of Cities and the Palm Beach County leadership of Palm Beach County who started this process. And so we'll be glad to help you, but we would want to be a participant and not necessarily leading this charge because we think it needs to come from all of us. Jamie?
I have a couple of closing comments. On behalf of the 38 municipalities and the 230 local elected and appointed officials that we serve, I think we all understand that every time that there's a prosecution or an accusation in the honest services fraud arena, it makes our job harder for each and every one of us, because it drives home the perception that we're all crooks, we're all in it for the wrong reasons, and it just makes it more difficult. And there are so many good people working to make our community a better place. I'm going to take away a simple matrix of 5 touchstones here today. We need fiduciary responsibility, common sense, our own personal code of ethics, obviously disclosure, and obviously transparency. And I'll leave you with a thought I used to teach my kids when they were really, really little, and they would talk about coming home and I didn't do it, they did it, you know. I just taught them the concept of the sandy hole of trouble. If you stand too close to a sandy hole, you're going to fall in. So with that, I thank the tax collector's office. I thank the city staffs, the county staff, and all the intergovernmental partners that we work with, and thank you for being here today. This was an excellent communication dialogue within the community.
Thank you.